believe that you believe the president did not have the authority to issue the notification, and in
as,
that first step, it was
as he did,
unconstitutional.
as he did.
To amend 367.
Because
Right.
secondly, the president also,
With this power.
an exercise of this power, also purported to add a clause in Article 367, which is clause 4. I don't know if you have got clause 4. If you have got a
2019.
constitution
Yes.
book on the constitution, you'll find that in the footnote.
It came on 5th of August, 1 day before.
It came on 5th of August.
So amending
Right.
this.
Amending, yeah. To Article 367 shall be added the following clause. So the purposes of this constitution as it applies. Now, this is not done by an amendment to the constitution. This is done again by a notification, which is again invalid. There is no such thing.
Amending the constitution.
It's an amendment to the constitution. How can you add a clause by a notification? Who authorizes you?
So at the very first step, the presidential notification is where you think the unconstitutionality lay.
Yeah, absolutely correct.
So
Absolutely.
the unconstitutionality is in the presidential notification,
Yes,
according to you.
And it makes no difference whether this was a transitory provision or it was a temporary provision, because Article 368 says any provision, which includes a temporary provision. So it makes no difference. What difference does it make? It was added in the constitution. It has to be taken away by an amendment. You can take it away. Who's stopping you? If you have the requisite majority, take it away.
So the proviso was a safety, the recommendation of the
But then
constitution.
I don't know whether this was argued, not argued. I'm not trying to be too clever. That's not my point. You ask me my opinion. I'm giving you what I believe to be the correct position in law.
Okay. I think I finally properly understood your position, but can I ask you one more question, which strikes me as confusing? The special status to Jammu and Kashmir is now gone. The Supreme Court has upheld that decision. But there are plenty of other parts of the country, in Article 371, that continue to enjoy that special status. Is that not a contradiction in law?
And that's all right. That's perfectly all right. I don't see anything wrong in that. Yeah, a lot of them. In fact, Sikkim, if you will, I don't know whether you know, Sikkim was added. You'll find one of the sub-articles says 371 blank, what Q or BP or something, which relates to Sikkim. It gives you special powers for Sikkim, which are not there for any other state. This whole chapter is like that. The whole temporary and
But how do you legally explain taking away that proviso from one state but keeping it in others?
because that is a proviso which mention only it applicable to J&K, because it speaks of the Constituent Assembly of J&K. It has nothing to do with any other. There's no proviso applicable to every other. It's a
Can I ask you?
Assembly of J&K. That's all. Yeah.
Can I ask you in the end if you believe the last legal word has been spoken on this, given that the presidential notification was not part of today's verdict and the judges specifically said that this had not been challenged, the president's power to do this?
No. It was the proclamation of emergency which was not challenged. That is what the court says. Sorry, it doesn't say so.
Presidential rule.
That is the proclamation. You are mixing it up with the presidential proclamation, governor's proclamation of emergency, of declaration. That's a separate proclamation. That has nothing to do with this.
So do you believe the last legal word on this has been spoken, Mr. Nariman?
I don't know. That you are better find out. I have no. I just give you what my view is. That's all. At the moment, until this is amended or set aside or whatever it is by the court itself, we have no authority to say this is wrong. That's my view. I don't accept this view. I can't go on television and say this judgment is wrong. So the judges have to answer me. They'd have no business. They say I don't give a damn for what Nariman says.
I'm sure they give a damn for what you say, but if I may conclude this conversation by saying you will not disagree with the verdict, but you will say that before this verdict, you believe that the procedure was not followed properly because it was done by a presidential notification. That's how the ball was set rolling.
And it's a substantive procedure. It's not just procedural. It's a substantive provision. Remember, clause 3 is hedged in by the proviso. the president is not given the power himself.
His power
It is
is
given
limited.
only if it says shall be necessary, only if the Constituent Assembly of the state so decides. Now, there is no Constituent Assembly, agreed. There is no Constitution of Jammu Kashmir, that's gone, agreed. Therefore, this proviso has still remained. It's in the book. You have to remove it, therefore, first, before you do anything else. So you remove the proviso, then everything falls into place.
But of course, what you're saying is in contradiction to what the judges thought today.
Beg your pardon? Yes, that's correct. That's correct. I don't know whether that was argued, not argued, etc. That you better ask the people who argued it.
Are you disappointed with the verdict?
No, why should I be disappointed? I am not a Kashmiri or a non-Kashmiri, etc. I'm a citizen of the country. I have to accept the verdict. That's my point. As a lawyer, I have to accept it. I mean, that's a constitutional thing. It's binding on you also, Barkha.
Barkha.
Article 141 expressly says so. It's binding on all of us. This is our constitution. So we can't balk at it and say these judges are wrong, these judges are right, etc., etc. That's not our business. We have no authority to say that. So we have to be very careful what we say.
Yes, of course. We don't want to be in contempt of court, but I think what
I'm not bothered about contempt. There's no contempt if I said the judgment is wrong. There is no contempt. But I don't wish to say the judgment is wrong, because I think that's not part of the duty of a lawyer to say that a judgment is wrong. If the lawyer is advising other people who are non-lawyers on something that is concerned with the Constitution, he has only to say that this was my view before the court decided this question.
Can I say, at least correct me if I'm wrong, that you will not contest the verdict, but you do believe that the government made a mistake by going the route of the presidential notification when it sought to bring this change?
Yes, correct. Absolutely correct. Because for two reasons, as I told you, that they had to first remove the proviso to Article 370, Clause 3, which they had not removed. And that could only be by a constitutional amendment. And the fact that this is a temporary provision or not a temporary provision makes no difference, because it says any provision. Article 368 says any provision can be deleted or added to or subtracted from, etc.